Hi, everybody. This is Matthew Stubenberg from the Maryland Volunteer Lawyer Service. This is the Advanced Expungement webinar, so I hope everyone's in the right place. We're just going to give it another minute or so for some late people to arrive, but we got a really good panel for you today. This video is actually going to transfer too well. This is Chris.
Hello.
1B4J, also an expungement guru in his own right.
I always learned.
You can just go to the last one for me.
You just want to start?
Yeah, that's fine.
This one, right?
Yeah.
Correct. What is it? We got 12. We'll give it another 1 minute here before we get started.
Too bad. I feel like I should have prepared a slide. That's a good for Schlub.
Hi, welcome. Okay, we're going to go ahead and get started here. So my name is Matthew Stubenberg again. I am the IT director and the expungement staff attorney here at the Maryland Volunteer Lawyer Service. And first, what I'm going to do is I'm going to discuss the legislative updates on expungement here that happened in the legislature in Maryland here recently. So there was a number of things that were put before the legislature. Some really ambitious things as well, including automatic expungement, waiver of all fees, removing the 3-year waiver of liability. Unfortunately, a lot of those got struck down at some point during the process. There were 2 expungement-related ones that did get through that I believe are sitting on Governor Hogan's desk. I don't believe that any of them have been signed yet. But the first one is HB 382, which allows for any civil offense that to be eligible for expungement. Now, it still follows the rules of expungement, but if we remember under 10-105, it used to say any civil offense that could have been charged as a criminal offense. It was kind of a very oddly worded language there. And my recommendation to all the attorneys was basically to treat every civil infraction as a substitute for a criminal offense, and so follow the normal expungement law as it is. So now they've gotten rid of that language, and you can treat every civil offense or infraction as a normal criminal expungement case. It doesn't mean necessarily they're all eligible, right? You still have to follow whether or not, if it's a conviction, if it's not eligible under one of the exceptions, it's not going to be eligible for expungement. But now that one piece of language in the very top of 10-105 no longer means you have to determine if it was brought as a substitute for a criminal charge. It's a little confusing. If you have questions, feel free to email me later. The second one that passed was SB 101, and this adds on to the Justice Reinvestment Act, and it allows for the first time for some felony convictions to be eligible for expungement. So previously, under the Justice Reinvestment Act, only convictions on misdemeanors and only certain misdemeanors were eligible for expungement. This allows in 3 different convictions. It's possession with intent to distribute, felony theft, and burglary. And so those, if they still have to follow the same rules under the Justice Reinvestment Act, which is, no subsequent convictions. There's the possibility of having it denied because of the interest of justice, all of those things. And these 3 new felony convictions that will become eligible follow the 15-year waiting period that assault second carries. And so if, assuming Governor Hogan signs it, there's no kind of changes to it or anything along the way, This will allow for possession with intent to distribute, felony theft, and burglary convictions to be expunged 15 years after any sentence or probation is completed, so long as there's not a subsequent conviction. So once all of that gets approved, I will send out more about that, and inevitably there will be another expungement training that will cover kind of the new changes to the law. All right, so we have three great panelists here today. I'm going to introduce them kind of as they present. The first one here is one of our great volunteers, Amelia French. She is an attorney barred in District of Columbia. She volunteers with the Maryland Volunteer Lawyer Service on expungements and the DC Volunteer Lawyers Project in family law. She's passionate about public service and graduated from the District of Columbia David A. Clark School of Law. As a student attorney, Amelia provided over 700 hours of free legal services in the community development law and legislation clinics, and she plans to begin her own practice this year in the areas of small business law and real estate law. And the reason I invited Amelia here to present today is she had a really interesting case relating to the violation of probation, convictions on violation of probation, and how they can kind of gum up the works of an expungement. So I will pass it over to her. Go right ahead.
Okay. So I'm talking about how violations of probation affect the expungibility of your cases. So what I did here is I just created a spreadsheet outlining when the cases would be eligible for expungement. And I always like to start with the latest case because the eligibility of your previous conviction is going to be dependent on when the last conviction is eligible for expungement. So looking at case number 2, that is where the violation of probation was entered in the record. And I will say this, I always like to say entered in the record or it was established, because if you're advocating for the expungement of a record that has a violation of probation on it, you don't want to make it seem like it is a criminal conviction, because under Maryland law, it is under the case law, it's very clear that they consider violations of probation to be civil proceedings. And under the Justice Reinvestment Act, it's only the new criminal convictions that are actually preventing the expungement of previous criminal convictions. So because a violation of probation is a civil proceeding, it wouldn't affect the eligibility of expungement of a previous criminal conviction. So what I did was with this particular client, I ended up attaching a brief to the petitions. And what I talked about was the fact that a violation of probation is not a new crime. And then I also talked about the fact that the violation of probation is not part of the same unit as the possession, not marijuana convictions, because under Maryland law, a unit is defined as charges, 2 or more charges that comprise or that have the same incident, transaction, or set of facts. So in this particular case, the violation of probation was, the warrant for the violation of probation wasn't instituted until June of 1987, whereas the facts that gave rise to the, that's actually when it was entered in the record. The violation of probation warrant wasn't issued until March of 1987, but the facts giving rise to the possession, not marijuana charges happened in October of 86. So completely separate incidents, several months in between them. So they're not a part of the same incident. They're not a part of the same transaction, because it's not like they were part of the same scheme or same plot. So it wasn't like they had to complete the violation of probation in order to effectuate the possession charge. It just doesn't make sense. So they weren't part of the same transaction because they weren't part of the same plot. And then they weren't part of the same set of facts, because the facts that you're going to use to prove that somebody actually committed a conviction, or committed a possession of not marijuana, you're going to use different facts to establish that versus the facts that you would use to establish whether someone violated their probation. And in the present case, the client actually just did not submit to your analysis, weekly, and then also the client changed the address without notifying the proper authorities. So completely different instances, completely different set of facts, and completely different transactions. The other thing is, if you look at violations of probation and you compare them to criminal proceedings, they have different characteristics. So in a violation of probation proceeding, what you'll see is that the standard of proof is going to be preponderance of the evidence. If you're looking at a criminal proceeding, the standard of proof is going to be beyond a reasonable doubt. There's also additional protections that a defendant is going to be due in a criminal proceeding that they are not going to be owed in a violation of probation proceeding, like having a right to counsel. That is not something that you are automatically afforded in a violation of probation proceeding. But because you are at risk of going to jail, they have to have an actual proceeding to determine whether you're going to stay on probation or whether you're going to go back to jail. And that is the only thing that is being decided in a violation of probation proceeding. When you're actually when they're evaluating whether you committed a crime, they're looking to see whether you actually did it, not whether you're going to go to jail necessarily. So that was basically what I described in my brief, and I haven't gotten an objection yet, so fingers crossed.
So you had a client, so your client was originally charged with the probation before judgment, which only has a 3-year.
Correct.
And then the theft, which is eligible. But then the violation of probation on the conviction is kind of gummed up all whole works. Without the VOP, could everything have been expunged?
Yes. So with the PBJ, there was the conviction for theft that happened 2 years afterwards, but because the guilty on the theft is eligible under the JRA, it wasn't going to affect whether the PBJ was going to be eligible for expungement. So.
Perfect. So it's kind of multiple tiers of different subsequent convictions to look at. Do you have any advice for attorneys who come across a violation of probation conviction? Because I know I have a number of times, and I always kind of struggle with what to do.
Well, I would say that, how I was describing earlier, that I didn't have to go before the court for a hearing, but even just attaching the brief, I think that probably signaled to the state that they didn't need to object, because it was now pretty clear that the violation of probation was not going to prevent the expungibility of the criminal convictions. So I would say doing something like that. And then also, if you do have to go to court, remembering not to say that they were found guilty of a violation of probation, because you're arguing that it is a civil proceeding, so you can't be found guilty of something that is a civil action.
Fantastic. If anybody online would like to ask a question, you can, I believe there's a way in the webinar to either ask it in the chat box, or you can ask a question, or you can just raise your hand and we should be able to unmute you. The chat box is right here. So anybody, and for all the people in the room, of course, you can, it's not quite such a complicated digital way to do it. All right. Well, if there are any, if you're still contemplating all of the kind of multiple subsequent convictions and exactly how they all add up, and you have a question that comes to you in a few minutes, feel free to ask it. I'm sure we'd be happy to come back to you. But in the meantime, we're going to move over to our next panelist. She is Kate Cook. She graduated from New York University Law School. She was a prosecutor in New York County for a number of years. Then she joined private practice in D.C. before joining the FDA, where she spent more than 20 years as their counsel. She now works for a consulting company in D.C., and she is dedicated to pro bono, and she tries to join a pro bono clinic at least once a month, take on pro bono cases at least once a month. So I will pass it on to her, and she had a very interesting case about no findings, which are kind of unique to Prince George's County as a disposition.
Hello, I'm Kate. It's nice to be on the phone with you all. I have my full slide, and we can go to the next slide, Matthew. So what is a no-finding disposition? I think that's what you're all asking. And here it is on that slide, and you look at the disposition. It says no finding. And if you run this this entry through one of the turbo expungement programs, it will come up with it will tell you it's expungible, and it'll come up with a standard petition that you can file. And that's what I did. But I'll tell you, I think after having been through this, you may find that the state's attorney's office will object to an expungement petition. And at that point, I'll tell you how you can respond, but I'll also suggest that under these circumstances, if they actually do object, it may be appropriate to file an additional petition requesting expungement on different grounds, on the grounds that, quote, the case was otherwise dismissed or quashed. So as Matthew mentioned, this is something that seems to be specific to Prince George's County and actually to one judge, Judge Famia, who is in his 80s and is still on the bench, I believe in a kind of part-time senior status role. And I gave a link on my slide to a local practice just because they describe Judge Famia's courtroom as something that deserves a different approach because of his interest in clearing the docket of cases that he thinks aren't serious and trying just to move things ahead. Next slide, please. So after I filed that expungement petition, which had, the case was, I forget, it was I think the first one said it was dismissed before adjourned in contemplation of dismissal. The state objected, and this was what they said. They said a disposition of no finding or nolo contendere has the same legal effect as a plea of guilty. Under Maryland law, I summarize what they said with limited exceptions. Guilty convictions are not eligible for expungement. Well, there is no provision in the law about no finding. And I was a little puzzled by that. I hadn't practiced in Prince George's County, and I didn't really know what that meant. And I spoke with the lawyer who had represented my client, and he's still in practice, and he said, oh yes, Judge Famia does this. He just does this as a way of moving misdemeanor cases that he doesn't think are serious through, getting rid of them. So next slide, please. And I'll tell you, I'm telling you how I was prepared to respond, but in my case, it ultimately was a little bit easier because the court took the issue of my particular expungement petitions down a different path, having to do with the confusion of a record with another individual, which required another kind of clarification. The question there was whether there was an active case or not. But this is how to respond if you do have this objection raised. First, the statute, the expungement statute, doesn't reference no finding dispositions, and they're not equivalent to a nolo contendere disposition. Nolo contendere, that's the Latin. It means I don't wish to contest the charge. This is going back to law school. If you remember the old Alford plea, this is where a plea is entered where the defendant says, I am not admitting guilt, but I don't wish to contest the charges, and I'm just going to enter this plea because I want to be done with this. So the first thing I would suggest you do is to determine whether there actually was a plea of nolo contendere. You'll find that if you wanted to get the minutes of the court appearance, that may well be very difficult because the court stenography notes are actually destroyed. I think the record retention schedule is only 3 years. So the court stenographer notes may not be available. But I did go to the circuit court docket, to the clerk's office, and had them pull the disposition sheet. And I got them, my client actually had a number of these. I think there were 8 cases that were no finding dispositioned on one day. And the interesting thing about this is, even though there was some kind of scratching along the nolo contendere space to enter a disposition on these sheets, which at least as recently as these cases were handwritten, they weren't computerized entries. It was also noted that the plea was entered in absentia. So my client wasn't present in the room when the plea was entered. And that's important. You know, entering a guilty plea is not something you can really do in absentia. And it turns out entering a nolo contendere plea is something you can't do in absentia. Next slide, please. And in fact, the Maryland Rule of Criminal Procedure is very specific on the conditions that have to be met for there to be a valid nolo plea. A nolo plea must be entered personally, on the record, in open court. The nolo plea may be entered only with the consent of the court, and the court cannot upset the plea until after an examination of the defendant on the record in open court. And that could be conducted by the court, the state's attorney, the defendant's attorney, or any combination thereof. And the court has to determine and announce on the record that the defendant is pleading voluntarily with the understanding of the nature of the charge and the consequences of the plea. And the defendant must be advised of the collateral consequences of that plea. So in my situation, in my investigation, it was pretty clear cut that this was not a nolo plea and the state's attorney's argument was not supportable, and it did fall by the wayside. And that's a good thing. But what would you do if you didn't find that the court sheet said that your client was present? Or what if the court record showed your client was present at the time of entry of the plea? And what if it was characterized as a nolo plea? I think that's a more difficult case to make, especially because it will be difficult to actually obtain those stenography notes. Remember, they're destroyed after, I think, 3 years. But on the other hand, these no finding dispositions are very well understood, I think, by all the judges in Prince George's Circuit Court. So I actually think the state's attorney may make the objection, but the way to address it would be to actually say, well, this was a no finding, and then what would be the evidence that you would present? You could interview any of the lawyers who were present. Your client might have been represented by legal aid, maybe by a private attorney. Their records may indicate something about the plea disposition. When I was trying to decide what to do in my case, the prior attorney had actually suggested I speak to Judge Famia. I didn't do that. I think that would have been a little tricky, but that, if your back is against the wall, that's something that you might do. So I think I'll ask now to see if there are any questions about this.
So it sounds like if you find a case with a disposition of no finding, the best bet is if you can find the original docket sheet from that day that states whether or not they were actually there in person the day of the guilty plea, right?
Absolutely, and it's quite possible it wouldn't be objected to by the state's attorney unless, because, well, Matthew, what's your experience? Are they objecting to these more and more often on these grounds?
I feel like initially they would go through and I would get them expunged, but I feel like recently they've started objecting to them.
Yeah. Well, I think you need to be prepared based on the docket sheet and based on other evidence you can develop to show that this was not a nolo plea. A no finding is not a special category of plea. It's an expedited way to get a case dismissed. But the docket sheets they're muddled, to tell you the truth. In some ways, they look almost like a guilty plea was entered, but you're best off if they do indicate, as mine did, that the client was not there.
And was there a hearing on this, or did the state withdraw their objection?
Well, the client had objected, the state had objected on two grounds of objected to the petition on two grounds. One is this no finding, nolo, prior conviction. The other was that my client had an open case. The court actually ruled on the petition before I even had before I received anything from the state's attorney's office. I found there was about a month delay in any kind of mail related to this. And the court actually ruled the case was not expungible, but because of the open case issue, which we're still working through.
And I will state, too, that I've had that happen in Prince George's County court before, where the petition will simply be denied by the court, which I don't, under the statute, the expungement statute, I believe a hearing has to be held if the state objects. So I'm not exactly sure how that happened, but I can attest to that happening to me as well.
Yeah, it actually happened within 4 days or so of the state's attorney filing an objection, which was way too expedited, I think.
Well, if there are any questions for Kate, we can field them now. I noticed that there are 2 questions here in the question box. It doesn't look like they're exactly related to Kate's, so I'll just go ahead and answer them here. The first is, can you shield a peace order and expunge it, or only one or the other? So good question. With peace and protective orders, you cannot get them expunged. However, you can potentially get them shielded. It's not under the criminal shielding statute that was passed under the Second Chance Act a couple of years ago. It's actually a totally different shielding statute. There's a couple of pieces that have to be met. It depends on how many other peace order and protective orders or criminal actions the 2 parties have together. We don't do them at MVLS just because they almost always require a hearing, and it's a little bit more complex, not quite as straightforward as expungement. But good question. The second one is, am I correct to assume that the eligibility date is set for 10 years after the most recent conviction? So that has a lot of caveats, and it depends to it. Under the Justice Reinvestment Act, for certain misdemeanor convictions, you have to wait 10 years from the end of any sentence or probation. And now, if that person receives another conviction somewhere in that time frame, 10 years plus sentence and probation, then you have to wait 10 years from the end of that subsequent conviction in order to get everything expunged. Now, if the subsequent conviction is for something that's not eligible, like a conviction on murder, then the prior conviction is simply locked in. It's now no longer eligible for expungement. So I hope that now makes sense. If there are no other questions, we'll move on to our next one. Just check the chat box here, make sure. All right. So let's move on with our last panelist here, Alex Felix. Did I say that right?
No.
No, not even close.
Eric Felix.
Felix, sorry about that. Eric graduated from University of Baltimore Law School, and then he went on to get his LLM in taxation from the University of Baltimore Law School. And he's now an attorney at SH Block Tax Services and one of our great expungement volunteers here. And so he's going to be talking about a great issue. Go ahead.
Yeah. I think before I just want to add on to Kate, what Kate and Matt were talking about with PG County is that I had one in PG County where the state's attorney objected to it. They didn't post their objection until the day after the court signed off on it. So now it turns out I wasn't going to get that one anyway, but
it's kind of an interesting little workaround there to try.
Yeah, it's a dirty little place, so watch out for that. But what I'm here to talk about are arrests for fugitive for justice. So this is where someone gets arrested in Maryland on an out-of-state warrant. And I think it's an open question of law whether or not these are expungible. And the reason is, if you look at 105, a person who's been charged with the commission of a crime, ... Crime is not defined by statute. So my position is that it is open to judicial interpretation as to what constitutes a crime. And I would say that, and my argument has been, and so far has not been successful, but I'll get to that, has been that, my client was detained by Maryland law enforcement authorities, deprived of his freedom, subject to Maryland criminal procedures. You don't become a fugitive from justice just because there's the implication that there's a crime there, an underlying crime.
How does somebody get a fugitive from justice charge?
It's when they get up, if they get pulled over or they get stopped by the police or they somehow wind up on the police radar and the police do their check and there's an out-of-state warrant. And then, so in my case, I later learned that there's a violation of probation in Virginia for my client. That's what he was picked up for. So I think it's an open question of law. A lot of judges disagree. Judge Sweeney of the district court up here in Baltimore, unprompted in open court with it, not really having to do with anything with the case before her, flat out say, fugitive from justice is not expungible. Other judges their mind is not as firmly made up. So the case that I had with a fugitive from justice was before Judge Taylor here in the district court for Baltimore City. She was open to my argument about a broader definition of crime for the possibility of expungement. She had a little trouble because there's been so many revisions to the law recently that if the General Assembly wanted to include it, they would have explicitly, but she didn't. She was persuadable, and I think probably other judges might be persuadable. And I think that's going to be a key thing to remember throughout this is there's no case law. It's an open question, and it's got to be up to any individual judge. What hurt me, where her questions were focused on, she had no idea whether or not my client was actually extradited to Virginia. I had assumed, based on case search, saying that the case was dismissed, that it meant it was dismissed. But apparently, it might say dismissed even if the person is actually extradited. So that was an unclear thing that she was unclear of and she wanted to know about. She also wanted to know how the case in Virginia was disposed of. My client had dropped off the grid, so I was not able to present him as a witness. I wasn't able to talk to him about it. And I think if I had him testifying, if I had more information about what went on, if I had access to the file, the district court up here in Baltimore is not conducive to going down and asking for the file to see what went on. So I would say if you get a case, someone coming to you and they have a fugitive from justice, understand that if you agree to take it on, you're going to be doing quite a bit of work. I would say especially if it's district court, I would say you're probably doing a trip to Annapolis to pull the file from the archives before you even file anything to see exactly what the disposition was. Make sure that your client would be available to go to a hearing, that you can commit to go to a hearing, and get some understanding about what the out-of-state warrant was about. What was the end disposition? Was your client extradited? If he was, what happened in that other state? The more information, the better, and the more persuasive the information, the better. But even then, depending on what judge you're before, they might just say no. So before you agree to take on a case with fugitive from justice, understand that it's going to be a lot of work and a lot of uncertainty. I think that's probably the biggest takeaway.
What's the case look like on case search?
There wasn't much to it. It just, when he was arrested, when he was released, and that the case was dismissed. I mean, those were the highlights.
I remember because I've challenged some of these before and had various results. But a fugitive from justice charge looks like a criminal charge on case search, right? Like, even though the state argues that it's some kind of civil piece to a larger puzzle and not really a criminal charge, to the public on case search, it would look like any other criminal charge, right?
I absolutely agree. I think that probably would have been a piece of my argument had I gotten past the stage of, well, what happened.
Right. So as you know, because I've had one of these before, and I argued that it looks like a duck and quacks like a duck, that the state can't then come in and say, well, I know we've done everything to make it look like a duck, but now we're arguing that it's not a duck. Mm-hmm. And it'll, on case search, it'll say in the criminal system, it'll have a criminal disposition of dismissed, it'll say the criminal charge was fugitive from justice. And the state's the one who controls what case search looks like. And so it seems kind of, wrong for them to come back and then say, well, we've made it look like a criminal case, but it's actually a civil matter that doesn't fall under the expungement statute.
Yeah, and a bit, of past experience kind of bit me when I saw this. So, piece of background: one of my first jobs out of college, I had a temp gig as a receptionist and file clerk for the state police, and one of the units I supported was the expungement unit, the extradition unit. And there'd be calls all the time, and there'd be plenty of times where someone got picked up in Maryland on an out-of-state warrant. Calls were made, and New York isn't going to pay to extradite someone from Baltimore for turnstile hopping. That's fairly common, and I think that colored my perception. I just kind of assumed when I saw dismissed, I assumed what happened was Virginia took one look at it, it's like, we're not paying to have this guy brought down to Richmond or Norfolk or wherever. And I think, and of course, being the attorney, I couldn't testify to my experience being there, so that colored my perception. But I think the thing to be aware of is that when you see a dismissal of a fugitive from justice, that's not necessarily a dismissal. That might just be a bookkeeping entry.
I've seen that too. I don't think I've ever come across a fugitive from justice charge that wasn't dismissed in case search. I think that's just kind of the policy that they have, that once they effectuate the warrant, they just dismiss that charge. So yeah, I think it is kind of very confusing because it's not based on what happens in the other state. And I had I've had taken on 2 or 3 of these now, and I've only won one. So it's definitely an uphill battle, but they are technically winnable. It's just going to almost certainly require a court hearing and some legal research.
And a judge who's willing to go along with you on that.
All right. Well, I'll open it now to any questions to any of the panelists, not just Eric, on fugitive from justice charges, a violation of probation, subsequent conviction or conviction on that, and a no finding disposition from Prince George's County, which is kind of a unique disposition in and of itself. Or if you have any other kind of interesting expungement gray area questions, we're happy to hear about it.
Well, what do you think the difference is between fugitive from justice versus violation of probation? Because I feel like they're both civil proceedings, so I'm not really sure why you weren't able to expunge that. That's
To be honest, I hadn't really looked at that underlying theory of it. I was looking very much simply of, here's a criminal case, it's in the criminal system, the disposition was dismissal, the only question is whether or not it constitutes a crime. So I think that's an interesting intersection between your experience with the violation of probation and my issue, which I just hadn't thought to explore.
Yeah, it's I think there is a lot of overlap with the kind of violation of probation has a proponent of the evidence standard,
Right.
and I'm not even sure you get to if a client gets to challenge a fugitive from justice charge.
Yeah, I don't even really like that because, I mean, if somebody has a warrant out of state, if they're in that particular state, they're just going to be brought in on that charge. It's not like they get charged with a separate charge because I found you and you didn't submit yourself to the warrant. I mean, there's not even a notification process for you to know that you have a warrant out on you unless for some reason you get arrested on some other thing or you get pulled over at least. So I don't like the idea of there being a fugitive from justice because it kind of, it makes people think that you are trying to evade being arrested in the other state when you may not have even known about it, you know, so anyway. I guess that's my soapbox, but.
And in the one fugitive from justice case I did win, what really helped was the fact that the defendant had been extradited to the other state, and when they went to the other state, they immediately were released because the police realized that wasn't the guy they were looking for. So all the charges in that other state were dismissed. And the fact that I could actually prove that and really helped the judge, I think, overcome it, because had everything happened in Maryland, there wouldn't be any question about whether it was eligible. It was only because it was bifurcated into two states almost. So yeah, very, very interesting. Well, can I get a big round of applause for our speakers here? And before we go, I just want to give a pitch for 2 expungement clinics that we have coming up. On May 17th, we have an expungement clinic at the Helping Up Mission. It's going to be from 2 to 5, so it's during the day. And then on July 16th, we have another expungement clinic from 9 to 11, also during the day, at the War Memorial in Baltimore City that we're all looking for volunteer attorneys for. So if either one of those pique your interest, you can volunteer or sign up online at mbLSlaw.org, or you're all going to get an email after this webinar with my email address and links to how to register. And you're more than welcome to send me an email or register through the links that get sent in the follow-up email after this. But thank you so much for attending. We'll stick around for a little bit longer if anybody has any last-minute questions they want to post into the chat box or the question box. But other than that, thank you so much for attending the webinar. Good work, everybody.
What time did you say the clinic was in July?
Good question. It is from 9 to 11.
Okay. I'm going to sign up. Can't do the May one, but I can do this one.
We got one thing. Do you guys have any good advanced expungement stories of expungements that just went wrong from the very beginning?
We're dealing with at least one right now where it's popping up on a CGIS search. Yeah, and so it's an arrest without charge. Right, it's popping up as an arrest without charge on the CGIS report. And when Chris called it was in Baltimore County, when he called the police department to find more information up there, they said that there was a court date, it went through, there was disposition. I went down to Annapolis and basically had her maiden name, her name right now, and the case number that was given to us by Baltimore County Police. And they were like, this case number is not the format of a case number in 1978. It's not even close. We don't know where this number came from. But then they just looked for anyone close to that name who had any charges that year in Baltimore County, and nothing came up. And so
Man, sounds like the beginning to a John Grisham novel there.
That's where we're at right now. I haven't called
Right.
the police department back again and been like, you lied. Try to do that as diplomatically as
Right.
possible. Yeah.
It's hard. Like, I need you to help me, but I'm kind of mad.
That's probably been the most challenging we've come across yet. A couple of situations of where like there's more or less an error along the way in case search, and we're just really missing key information. The disposition just won't be there.
Right.
And it's this sort of this magical disappearing disposition, and then we sort of try to figure out what's going on there.
I have a case where I need police records for drug paraphernalia guilty to prove that it was not that it's no longer a crime, that it was marijuana.
Interesting.
But the person was arrested while crossing the Bay Bridge. And
I remember when we were working on that one.
yeah, I think this is a different case though.
Yeah, really?
The special police department that just
Yeah.
is for, it's the transportation authority, and they are claiming that they don't release any records, that you have to send them a subpoena. So
Yeah, I wondered about that too with my client who supposedly had an open case and it wasn't him. I wanted to get his the arrest photo, and they wouldn't give that to me under FOIA.
Wow, not even under FOIA.
Yeah, the FOIA. Can we get subpoenas on these? What do we have to do to get a subpoena on one of these?
I was thinking that it would have to go to hearings before it's allowed to subpoena. Is that correct? Because otherwise, there's no like pending case that exists to subpoena for.
Yeah, true.
That's a good question.
I guess maybe you'd have to do like a Public Information Act request, and then when they say no, then you have to escalate using those procedures maybe?
That could be one mechanism. I guess once you have the objection from the state.
Right. Then there's
Right.
I guess that would be enough grounds
Huh.
That's another issue we've had with that particular police force. They're just on the bridge, and it's amazing how many crimes they charge people with just in that little jurisdiction.
And then even if you have the paraphernalia, I mean, like, how do you prove that it's connected to him? I guess it was specifically used for marijuana, but
Usually with my clients where the charge is just paraphernalia, it ends up being that they had like a blunt, so like a cigar that was like broken up.
okay, so that's pretty clear then.
So then it can be easily argued that that was for marijuana.
Interesting. Good. I guess.
And it'll often say it was marijuana residue, but they don't get charged with marijuana possession for some reason. They just get charged with CDS paraphernalia.
Huh.
Yeah, I've never seen paraphernalia referenced in an arrest report where they didn't try to associate it with drug that it was being used for.
For a little bit, it was marijuana was decriminalized, but paraphernalia for marijuana was not.
Mm-hmm.
And so you'd get some people who were convicted of just the paraphernalia because they couldn't get convicted on the marijuana, which didn't make any sense. Right?
Yeah. Illogical.
How do they even do that if it's like legal to sell?
Or like a bong?
It would be like the wrapper around a joint would be illegal, but the weed in the joint would not be illegal. And
Wrapping papers?
yeah, that would be the paraphernalia.
Right.
Then you'd have to find the marijuana residue, right? I mean, what if you just said I was smoking tobacco?
Well, usually they're caught with the full joint.
It's with the joint.
Yeah, and so it's not quite so hard. Yeah, I mean, then, it's like I don't know how you would do it, but if you just had the marijuana, you're in the clear. It's as soon as you add a piece of paper to it, that's when you break the law.
Right.
They did finally reverse that.
That's crazy.
That's an absurd result. I'm pretty sure there's some Latin phrase that clears that up.
Sounds like there should be, yeah. There's actually a good legal thing is that the assembly passed it, and I believe the governor vetoed it, and then they overrode his veto and added in there. So that's the whole legislative.
Is this under Hogan?
Yeah.
Why did he veto?
I think he had bigger issues with the bill as a whole or something. I'm not exactly sure.
So I had one I was going to ask you privately about. So I have a business owner, right? and it's a theft charge, and the complainant is actually his business. So and when you look at his description, the person is of a different race than him. So obviously, this is some kind of confusion. So just to go through that quickly again, you have the business owner charged with theft. The complaint is his business, which obviously it couldn't be.
Right.
And the description of the business owner that was charged is of a person of a different race. And
Man, we could have a whole another advanced webinar just on that story.
so, you know, this is what I was going to ask you privately. I can print out a petition, but I'm not comfortable signing a petition under those circumstances because it's misrepresenting facts.
Right.
In my opinion, even though the judiciary search furnishes those. So I guess I'd make some kind of special petition and.
Yeah, I mean, in theory, you could always, right, the expungement petition is just a form that the court creates. You could always, on your own motion, try to file something.
Right.
That'll be.
I guess that's probably what I would have to do. I would think.
So does this pops up on case search?
Yeah.
Could he do, I don't know if you've had anything like this, Matthew, could he do just like the CGIS report, which would be based on a fingerprint?
Yeah.
That's really what, because we did,
what?
CGIS, it's like the sort of, what does that stand for? Criminal Justice Information System?
I think so,
Yeah.
It's the like official sort of
Right.
storage of all of these details, and it goes off of at least the biometric of a fingerprint. So we regularly work with people who their buddies use their name.
Right.
And so there's like a bunch of charges that'll, and then, you know, Chris's concern with expunging those would be the sort of that whole ethical concern that you're technically not expunging your client's case. And so have we had anyone actually follow through with that?
What happens is, if we file it, well, we haven't, I don't think we've gotten someone to get the CGIS report.
Right, and then we would
But
just be
that's
able to,
something you could attach to a motion to show this doesn't appear on a fingerprint background check.
which would be much more official than case search.
Right.
So ostensibly, that would be when they rectify.
I think,
That makes sense.
wasn't there one, I don't think, this person was pro se, but wasn't there one where it was, like it was the guy's brother that was using his name, and I think that was Sweeney was presiding, and she was like, you know, no, this is not a, you know, this mistaken identity or whatever thing is not expungible, just like fugitive from justice isn't expungible.
Right. Well, we just got a contact at the state's attorney who's supposed to be taking care of issues in this realm where someone's name is a defendant on the case, but fingerprint shows that that's not them, that they weren't the defendant. I just sent this person an email yesterday, so we'll see what happens. I'm happy to forward that information along.
I mean, the simple way is it's clearly expungible. You send the petition in, but there's just a discomfort, as you know, making a representation that you know to be incorrect. So.
I think
The client was the defendant. I mean, it's like what are you?
No, my client was not the defendant. Okay, I'll just go through it quickly again. He owns a business, so you do a check. It shows him as a criminal defendant. His business is charging him as complainant with the theft, but then when you look at the records, you can clearly see, and he owned the business, by the way, he isn't going to charge himself. You can clearly see that the person they're describing is of a different race, different size, okay?
I see.
So it's a total disconnect in terms of.
I think it's just
The
a record
the
mistake of
information,
listing his
yeah.
name.
Or
I mean, he didn't ever charge anyone.
is it possible?
It's a very unique name, by the way,
Okay.
I might add.
Okay, so it's not a coincidence of just someone with the same name.
No, I mean, his name, he is a South African name, which is very unusual, okay? It's clearly his name that's listed there. I don't know how it happened, whether perhaps somebody got cute and used his name or something, I'm not sure, but what really confuses you is the complaint is the business.
Yeah.
So he routinely might charge somebody with a crime or be a complainant in a criminal case because of the nature of his business.
It sounds like a data entry error was made.
Yeah, that's
Right.
what I was
That's right.
exactly.
That's but how do you clean it up?
Right.
Is the question, you know?
Well, I think they were saying to attach the CJIS report.
Right.
And then, it's going to clear up the fact that these are the only ones that are attached to this person's fingerprints. So clearly, these are the only cases that apply to this defendant.
Okay.
So
And
you
anything
need
else?
to,
Or if you-
I don't know who you're gonna attach those cases to, but they shouldn't be on your client.
Was this in circuit court, district court, and how long ago was this?
It was 92 in a district court.
Okay, so you might want to phone down to the Maryland Archives and see if they can track down the file, because if it's a data entry thing where maybe someone, or whoever was typing it up,
Yeah.
looked at the complainant when they were typing in
Mm-hmm.
accused.
That's probably exactly what happened, especially since you said the name,
Right.
like, not normal, so.
Yeah, and
Some work to do on it.
yeah, you can take a trip down to Annapolis. Or I think there's like a $40 charge, and they'll send you a file, which sucks, but
So I've got another one.
Yeah, it's better
I'm
if you
doing
go
right
there
now. I
than
was gonna ask you
less
this
money if
privately,
you
I'll
go
ask you.
there.
So I met with the.
but call ahead, because a lot of the court records are stored off-site, and you have to specially arrange for them to be brought.
So I have a client that we talked about the other night who has an attempted murder conviction, okay? And then he has an all pros with regard to another attempted murder conviction. He claims that both of those are separate incidents, okay? The computer shows them as having the same incident date. And for what it's worth, I believe the guy. I mean, I went through a lot of detail with him on this. So I finally did get the petition to print out on the null process. And my strategy was to go ahead and file the petition instead of going and filing Freedom of Information, getting and all of that, to see what the court has to say about this. And if there's an objection, then obviously I will dig deeper into it. But that's the strategy. I have a good faith belief that, that this should be expunged, albeit it has an incorrect incident date on it.
Right. Yeah, that was kind of interesting, because they took potentially two separate incidents and put them in the same case number.
And the way it probably,
Yeah, there was a
not
case-
to interrupt you, but the way it probably happened is they have the same disposition date, okay? And it's not uncommon, as a prosecutor, not here, but a long time ago, if you've got a complicated criminal history, you bring it all together and, you dispose of it at one time, even though they're disparate or different charges, disparate incidents and charges.
Yeah, they're actually one of the few expungement cases that worked its way up to the Court of Special Appeals. It was a guy who was accused of a string of burglaries in Towson. He was convicted, all one case number, one tracking number. He was convicted of some instances of burglaries, but not others, and he got those others expunged because it wasn't a unit, because they were different. Each burglary was his own start and stop